Welcome back to a continuation of our discussion of the constitutional law of immigration. It's an immense and difficult subject, hence there is more reading accompanying this week than we have previously, and we will discuss only in very general terms what this constitutional law means. I hope that you will use the forum for considered discussion of some of these issues in more detail, and I look forward to reading those. What we're interested in today are what are the ramifications of the constitutional doctrine of plenary power. One of the most important was yet another case from the Chinese exclusion era. This one is Wong versus United States, and it was decided in 1896. The most important tenet of that case: deportation is not punishment. And we're going to think about what that means. We will revisit deportation in week 5, but for our purposes, what it means here is that there are a limited set of constitutional rights, very limited set of constitutional rights, essentially only a very minimal due process for persons who are being deported from this country. As I note here on the slide, it is a civil proceeding. By that I mean a deportation, and thus the constitutional protections guaranteed in criminal prosecutions do not apply. As someone has noted, a citizen has more rights in traffic court than a non-citizen does in a deportation hearing. What are some of these criminal prosecution rights? One is a right to an attorney. You have a right to have an attorney appointed for you in criminal prosecutions, even if you can't afford it. In immigration proceedings, by contrast, you may bring an attorney, but you do not have a right to have one appointed. And in fact, only about 20% of all deportations have lawyer involvement. So that's a very important part of the constitutional structure of immigration law in the United States, the fact that deportation and exclusion, they're not considered punishments, and therefore most of the Bill of Rights does not apply. But there are some further implications of the plenary power doctrine that are worth mentioning at least briefly here. Detention and deportation occur in an administrative tribunal, or summarily at the border. In our next lecture, we'll look at that administrative structure, but that's very different from our conception of courts deciding cases. As we noted before, another implication of the plenary power doctrine is limited judicial review. It's very difficult to get a federal court to hear cases that have arisen through the administrative process. And if they do hear cases, again, like in the Chinese Exclusion Act, very frequently the Supreme Court says this is a matter within Congress's political decision-making capability, and therefore we will not review it on substantive grounds. So that's what we mean by limited judicial review. And lastly, a topic of great interest today, federal preemption of state and local regulation of immigration. And in my slide here, I note some state and local regulation of immigration because there have been inroads in recent years. We're going to talk about one of the best-known decisions in immigration law in recent years, and that's Arizona versus United States. Well, as you know, in recent years, states and local governments have passed a variety of laws aimed at deterring undocumented aliens from living in that state, or at least a variety of measures that are designed to deter illegal immigration. Some states push for harsher laws on the theory that self-deportation is desirable. In other words, life will be so uncomfortable or so difficult for an undocumented alien that they will simply leave or return to their country of birth. Not all states have taken this approach, but most notably Arizona, Georgia, Alabama in recent years have been among the states. I want to talk about two very important decisions, both of which have helped define the rights of immigrants in the United States. The first one is Plyler versus Doe. The United States Supreme Court in 1982, in a case from Texas, held that undocumented children have the same right to attend public primary and secondary schools as do U.S. citizens and permanent residents. In other words, children may not be denied access to public schools on the ground that they are not citizens or that they are here in an undocumented status. So that's been the case since 1982. There are a number of other decisions that, like Plyler versus Doe, are based upon the 14th Amendment. Remember, when we looked at the 14th Amendment earlier, we noted that due process and equal protection are the rights of persons within the United States. They are not limited to citizens. So we know that immigrants, whether they are documented or undocumented, in other words, whether they are here with the government's permission or without the government's permission, we know they do have some basic rights. There have been a number of other decisions under the 14th Amendment, but this is one of the most significant and one of the most well-known. But that was decided a number of years ago. One of the most closely watched cases recently was a case out of Arizona, known as, in fact, Arizona versus United States. It's a complicated case that I'll explain briefly, but in the reading material you will have much more detail on this. In this case, the Supreme Court struck down 3 of 4 provisions of Arizona Senate Bill 1070. Senate Bill 1070 contained a number of provisions, all aimed at undocumented aliens. The 3 provisions that were struck down required legal immigrants to carry registration documents at all times. That was struck down as preempted by federal immigration law. The second provision allowed state police to arrest any individual for suspicion of being an illegal immigrant. And the third, preempted by federal law, Senate Bill 1070 made it a crime for an illegal immigrant to search for a job or to hold one in the state. All of those were struck down by the Supreme Court, although not unanimously. One provision survived. All justices agreed to uphold the provision of the law allowing Arizona State Police to investigate the immigration status of an individual stopped, detained, or arrested if there is reasonable suspicion that the individual is in the country illegally. This is the so-called show me your papers provision. However, Justice Kennedy specified in the majority opinion that state police may not detain the individual for a prolonged amount of time for not carrying immigration documents, and that cases of racial profiling are allowed to proceed through the courts if such cases happen to arise later on. So we have some basic parameters, but this is an evolving area of law, as some states push for harsher laws against undocumented aliens and other states do the opposite. It's not possible to provide a complete summary of the constitutional law of immigration, and we will revisit some of this in week 5 when we look at deportation. But these are some of the highlights. The major constitutional questions continue to be a limited form of due process for deportation and detention, as well as the line between federal and state immigration authority.
The preceding program is copyrighted by Emory University.